This is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat state, India, that is our Bharat. Today I have selected a very interesting and useful topic from criminal law. And the name of the topic is Corpus Delicti, that is body of the crime. But before I proceed in this topic, I would like to express my sorrows for the Pelgao terror attack by the terrorists. Innocent people have been killed. I'm, it has touched to my heart. So from the bottom of my heart, I express my sorrow for these innocent people who are killed. Now let us dive deep into this topic. This topic comes in Evidence Act, first of all. Corpus delicti literally means body of the crime in Latin. In its original sense, the body in question refers not to a corpse, but to the body of essential facts that taken together prove that a crime has been committed. Corpus delicti is a Latin word which is a combination of two words. Corpus means body and delicti means act contrary to law. That is crime. This is a simple definition. Corpus delicti means the body of the crime, not the body of the victim. In its original sense, the body in question refers not to a cause but to the body of essential facts that taken together prove that a crime has been committed. In popular uses, corpus delicti also refers to the actual physical object upon which a crime has been committed. In a case of arson, it would be a ruined building. In a murder case, the victim's corpse. In theft case, stolen materials. What should be the prima facie evidence? Prima facie evidence is evidence which accepted appears to be sufficient to establish a fact unless rebutted by acceptable evidence to the contrary. In no way it is a conclusive evidence. Now, what do we mean by corpus delicti? Corpus delicti has no reference to corpses. It means that before seeking to prove that accused is the author of the crime, it must be established that the crime charge has been committed. In theft, that the property has been stolen. In murder, that somebody has been killed. In case of arson, it will be a ruined building or in property. The strongest proof of corpus delicti in murder is the body of the victim or a vital part of the body by which you could be identified. For example, the body is burned out, but only head is available. So if you can recognize the head, if any relative recognizes the head, that is sufficient. In the absence of any such evidence, direct evidence may also come from a person who saw the calling or the murder may confess the crime. The circumstantial evidence should be so cogent and compelling that upon no rational hypothesis other than murder can the facts be accounted for. The strongest possible evidence should be required as to the fact of murder if the dead body were not forthcoming. The finding of the body is not absolutely essential. When the prisoners confess or where the circumstances are such as it is impossible to suppose that the man is still alive, or where death is proved by reliable evidence. Where bodies were unrecognizable due to decomposition and the postmortem could not determine the cause of death, the Supreme Court refused to hold that the deaths were homicidal despite alleged extrajudicial confession. S versus Vajan, A 1975 SC 258. Even if the corpus delicti is not found or traced, if there are compelling circumstances pointing to the accused as the murderer of the missing person, the accused can be convicted. This is a very important citation. Kanuchagan versus the State of Gujarat, 1982 Criminal Law Journal 110. Alternative, 1982 Gujarat LM 240. Suspicion, though a ground for scrutiny of evidence, cannot be made the foundation of judicial decision. Conjecture is not substitute for legal proof. Court's decision must rest not upon suspicion, but upon legal grounds established by legal testimony. Suspicion, however strong, cannot take the place of proof. If the proof of base leads to strong suspicion, the benefit of reasonable doubt should be given to the accused. Suspicion or supposition is not evidence. A judge is not justified in deciding a case upon a suspicion or upon mere supposition after discarding the evidence produced by the parties or where there is no evidence to support a finding. Means findings should be based on evidence. Undoubtedly, there are in the evidence circumstances which may create suspicion and doubt may be entertained with regard to the truth of the case made out by the appellant. But in matters of this description, it is essential to take care that decision of the court rests not upon suspicion, but upon legal grounds established by legal testimony. A finding cannot be made without evidence and upon a mere supposition. For finding, there has to be evidence. Evidence, legally admissible evidence. Conviction must be based on sufficient evidence, not merely on moral conviction. It means no one can be punished on moral conviction. Citation, 1984 Criminal Law Journal 1215. Judicial belief must be founded on reasonable ground and must rest upon evidence and reasonable inferences. Well, that's all in this video. Hope you find something new in this video. See you in the next video. Thank you for patient hearing. Thank you, thank you, thank you. Sri Krishna Saranam Mama.